Happy Friday, everybody. Welcome to the weekly privacy chat. I've been pretty good about doing them weekly, proud of myself, but easy to do when you've got great people close by to pull in to be part of these conversations. So delighted that FPF's Tatiana, our AI legislation lead, is with me, and special guest, Danny Weitzner, an old friend. I was just talking to Tatiana, who's a little bit younger than me, and Danny about the early days of privacy and some of the early people who were giant figures in my world. And Danny was one of those. For those of you who are of that slightly younger than me and Danny generation, Danny and a core of DC experts were the Electronic Frontier Foundation DC office, and working closely on some huge issues around law enforcement and surveillance and privacy, and ended up breaking away from EFF, which took a different path to form the Center for Democracy and Technology. So Jerry Berman, who's retired, but Deirdre Mulligan, many of us know from her long academic work, but her recent stint, at the White House. Jim Dempsey, who now is out at Stanford and doing some leading work for the IAPP. And what's his name? Our former NTIA leader,
Alan Davidson.
Anyway, the core of sort of amazing people who've gone on to many early. So Danny was at CDT when I started out at DoubleClick, I believe, and soon thereafter moved to a role at MIT, where not only playing an academic role in the computer science side of the world, played a key role for the W3C, which has a wide range of standards, and some are not so interesting to me, at least, and others have real policy and societal consequences. And Danny was the coordinator, touchpoint, host, as MIT played kind of a key role via him and other infrastructure in supporting the W3C's domain activity in that space. Anyway, served as a White House CTO, so is a creature of computer science, of MIT, of Washington, of advocacy, of academia, and been a great mentor and friend and advisor to FPF forever. Before I flag the issue that sparked this call, the piece that he wrote, Adrian has hopefully just posted a link to it if you haven't seen it yet in the comments. He wrote about recognizing and curing the cardinal sins of modern privacy, lessons from the new Texas privacy law. But his key point there seemed to be that if we're talking about regulating AI, state privacy laws, perhaps better versions, are the solution we need. So I'm going to ask him to explain what he actually meant by that, and Tatiana, who lives at the intersection of state and AI. But before we do, how do we not at least talk for a minute about the big news that Rebecca Kelly Slaughter, Alvaro Bedoya, the two Democratic members of the FTC, are out as a firing of the current administration. And obviously, many have expressed consternation about what this means for the rule of law, for independent agencies, huge consequences. Now that we're a couple of days in, I thought, well, okay, what does it practically mean in a narrow way for those of us focused on the functioning of the FTC, the functioning of data protection law, international transfers? The big first question, I was just getting on LinkedIn for this call, and I saw various European lawyers all already talking about opening up their cross-border assessments. What does it mean? What does it mean? And I guess the question is, what does it mean for cross-border assessment? So on one hand, the international flows were struck down because of concerns about U.S. surveillance authority. Danny played an important role during his White House days in the various negotiations that were happening. I forget if it was Safe Harbor 1, Safe Harbor 2, Privacy Shield 3, but in the various ongoing discourse. And the FTC And the fact that we had an independent FTC and a safe harbor agreement were key to the commercial piece of it. But what the court, had its issues with was the international surveillance pieces of it. So FTC has no play in that space. So it shouldn't be an issue for that part of it. However, the commercial piece, which was what we worried about for the first 5 years until somehow the court and others determined that GDPR, which I always thought kind of was limited to the fact that the European Commission and the DPAs don't have jurisdiction with regard to that set of issues. I didn't think GDPR did, but it turns out the court said it did. It was the commercial issues. So is there a risk? What's your take, either of you? What does this mean for the future of cross-border data flows?
I'll jump in quickly with just one word that's important to adequacy: independence. That is always been, from, as you rightly said, sometimes the adequacy debate about, whether the EU was going to recognize the US, I think very strong US privacy framework as adequate under the GDPR, as an adequate protection of European citizens' fundamental rights or not, always turned on in very critically the question of the independence of the enforcement authority. Then, as you say, you're right, there was this extra question about the supervision, oversight, and ability to, complain about law enforcement and intelligence behavior. But I think it does put the independence question back on the table. And I think it's really kind of a geostrategic question whether the European Union writ large wants to add that to its long list of disputes with the Trump administration or not. But I think it is, if they want to, they have a real basis for doing it.
Yeah, or even if they don't want to, because maybe they don't, at least the political mandarins at the commission, but others do, and Mr.
Right.
Schrems does, and there are already court.
Yeah.
I mean, the issue ends up.
Well, that probably takes time, and who knows? After that much time has elapsed, you never know where we're going to be.
Yeah. Tatiana, flavor on this?
No, I think that's all right. I mean, I think the FTC, as most folks know, is generally always been considered as like the US's version of a DPA, or as close as we can get to it, essentially. And the independence of that is extremely important. We have had a history where we had only Democratic commissioners, but this is just a different type of time right now, where we do have decades of, what is called like common law under the FTC regarding privacy, regarding security. And we're going to have to see how they start tackling those issues to see if they do maintain that independence. I think, of course, right now, a lot of people are questioning that.
Yeah. The one thing I'll just say about the domestic impact, as Tatiana rightly said, we've had different partisan makeups of the commission over time, but I think there's always been some effort with every single administration, every single chair, towards bipartisanship. And the minute I think that the minute the commission and the White House starts acting as if the FTC is just another cabinet agency that can be, directed at the will of the president, I think it turns those incentives towards bipartisanship, which I really do think have been important to thoughtful, balanced enforcement, into something very different. And I think I know both of the fired commissioners well, and I think they were outstanding public servants. And I really don't think they were there with partisan hats on. I think they had their opinions and their perspectives on issues, but I don't think either in the last administration or this administration they were there to advance, political bumper stickers. And I hope that the current chair can kind of find his way back to some more balanced approach.
One downside, I think, that is likely to play out, obviously, if the European Court strikes down safe harbor, this ends up, instead of jobs back here and data centers back here, this forces European companies to keep data locally, preventing, therefore, training and use by global US companies. It requires local data centers there, not data centers here. So from a economics and jobs negative. Now, okay, maybe we don't have an immediate court decision, but I think that real chilling effect, like I said, lawyers already saying, well, I don't know, there's risk here. This could fall, this might fall. If we're choosing between two vendors, we really should use a European one, even if maybe we prefer the US one. The price is better, the service is better, but there's real risk that in a year, in whatever period of time, I won't be able to move data. We saw this during the period when the Schrems decision struck it down. There was immense local pressure. It was good for the local market. In fact, the accusation often was, fairly or not, that, hey, this is a sort of a protectionist thing that is going to encourage, local spending. How much that's true or how much real effect, isn't clear, but certainly a real negative on the economics. Okay, well, hopefully we'll see what happens in the courts here. We're all learning names of cases that were not in my bailiwick. I never read Humphrey's Executor in law school. I don't know if they teach it nowadays, but I guess the case that I also hadn't read and should have read was the 2020 case where the I guess I read the high-level descriptions, but always assumed it was sort of unique to the CFPB. But now, obviously, reading closely and understanding how the court has been looking with kind of a gimlet eye at the notion that agencies that have broader rulemaking or broader policy-making authority might be, in the view of a conservative court, in line with the more unitary executive type theory, and that maybe you could have an FTC, but it would have to be a very modest FTC, as it was many generations ago. So, all right, let's turn to the topic at hand. Keir just sent around his fortnightly, what does he call it? Every other week privacy dispatch.
Patchwork dispatch.
Patchwork dispatch. We do have a patchwork quilt up on the legislative war room. I think the other staff get upset if we call it the legislative room, because it's just—
Is there a message in that? Is there a message in patchwork?
Somebody made a patchwork for us, and we take great glee in putting a star on each comprehensive state. And not that we are gleeful about the complications that are being made by the multiple states, but it's certainly a way to keep track. So what was your argument, and why was Texas sort of a good example for your argument? And how does it does seem like all the legislators who did state laws are now doing AI laws as sort of phase two? Is your argument that we don't really need all of these AI laws, or what was your point?
Well, let me say what kind of attracted me to the Texas case and why I think it addresses at least a very significant part of the concerns that we have when we think of regulating AI from a privacy or broader consumer protection perspective. I'm going to put aside for the moment the kind of existential threats part of the AI policy discourse. I'm interested in what you all think about that, but we'll come back to that. I'll say just a word about the Texas case, because it's a fascinating case, and I think speaks to really the flexibility of the newly enacted Texas privacy law and the creativity of the Texas AG's staff. So in a nutshell, the facts in the Texas case, this is a case against a mobile location data broker called Arity, which is owned by Allstate Insurance, one of the largest insurers in the country. And Arity collects data, according to the complaint, on up to 45 million drivers. So it has location data points and a lot of other driving metrics on a large number of people, certainly more than just the population of Texas, but there are plenty of them in Texas. The complaint, and what Arity does is it ultimately uses this data to develop driver risk scores, which it sells to insurance companies, itself, Allstate included. Also, it develops other kinds of profiles of the drivers to deliver advertising, other kinds of services to those individuals. The Texas, and what's interesting technically about Arity is that they realized both that they were going to have trouble doing sort of a complete data collection on their data subjects. So they actually pay various mobile app providers to use an SDK, a software development kit, in a variety of mobile apps. These are apps like Find Me the Cheapest Gas Near Me app and other kind of trip planning apps and other location-based apps. And Arity kind of helps those apps manage that location data, but Arity also gets back an enhanced version of the data that it shares out. So what you have is a very kind of comprehensive, I'll say it neutrally, collection of personal mobile location data, and a court that is being subject to all different kinds of uses. The Texas Attorney General, Ken Paxton, issued a complaint which said a couple things. Number one, that this practice violates privacy law, and there are 4 reasons. First of all, because the notice is incomprehensible. So even if you read the notice you get from Arity, you're not going to get a complete picture of all the parties who have your data. Number 2, the consent is ineffective because also there is no way for an individual to effectively control how their data is used through this rather complicated ecosystem of data that flows back and forth between it and all these apps. And where the law, I think, really steps into AI policy territory, according to this complaint, is that according to the complaint, Arity is obligated to give specific notice to all the data subjects about exactly who has their data and that it's being used for sensitive material purposes, such as the pricing of insurance and other kinds of underwriting efforts. And so right away, what you have, you can think of it as a privacy law, but you can also look at it and say, where does that risk score come from? That's a machine learning model that's operating on all this data, an AI model. It's not an LLM, most likely, because an LLM would be lousy at this kind of thing. But it is a model that is trained on driver behavior and applied to this very rich trove of information, generating a risk score, which is in this category of sensitive uses under this Texas statute, which requires, number one, specific notice, as we said, and number 2, the ability to opt out of those uses. And the Texas complaint says that the data subjects here are neither offered a way to opt out, nor would there even be a mechanism that existed to opt out because of the complicated flow of data amongst all these different parties. So I think what we have here, in a lot of ways, is a piece of regulation that addresses a prime use of what we would now call artificial intelligence. And I think what's distinctive about it, in the kind of, this goes, Jules, to your question about whether existing privacy laws are sufficient or whether we need to tweak them. The two things that I think are notable about this law is that there is this requirement of a specific kind of notice that addresses specific uses. That is, the Texas legislator said there are some harmful things or high risk uses that you have to have specific notice of. So you can't just write a super long privacy policy and say, yeah, we covered that somewhere. You actually have to be concrete. And second, you actually have to have the ability to opt out throughout the entire workflow. And again, you don't see that in you don't see either of those features in all of the state privacy laws, but this law actually has those features. So I'll stop there. I'm really curious, Tatiana, how you see it. But I think it's a very powerful example of what we can do today with a well-crafted state privacy law.
So to restate that, and let's have Tatiana respond to it. You're actually saying, I thought you were going to sort of have to lean on the automated decisioning parts of some of these laws, but many of the state laws don't go that far. They literally focus significantly on the basics, the notice, consent, and opt out, really the basics. And so are you saying that simply the basics of a good data protection law in effect address the issues raised by AI at least when personal information is involved? Okay, Tatiana, clearly you've been working with legislators across the country. They're all looking to do AI. Maybe part of it is just because they want to do AI. I always say, if I was still in the state legislature as I was many years ago, I'd be doing AI because why not? Of course, it's the hot issue. But they do seem to think that they need more. Why do they need more? Do they indeed need more? Does Virginia's privacy law? Virginia has a law heading to the governor. He will sign or not, I think, on Monday or today or Monday.
Today or Monday, yeah.
Soon. Virginia has a law that was a model for some others. It was sort of one of the more pragmatic, but it's got the basics of notice and access and so on and so forth. What's your reaction to Danny's argument?
Yeah, no, I think Danny's right. We obviously work at FPF. One of the things that we often do tell lawmakers is start with data privacy, right? Like data privacy, I think, at least gets you 75% of the way, because of course, a lot of these AI systems and the focus on more of these high risk systems that are, having these consequential decisions really fall in line with this case that Danny was just mentioning, right? A kind of risk score that's being used for a decision regarding insurance or a decision regarding employment or a decision regarding health, right? It's all in these same buckets, and all of that is also going to be based on personal data. So it does make sense that a data privacy law sets you up really well to be able to start addressing these risks and substantially addressing these risks that are associated. Where there is some level of gaps is when we start getting to the question of transparency of the specific systems, right? And any kind of indication as to whether they actually work and whether they're actually accurate, right? So there have been starting to become litigation in the courts regarding whether these systems are accurate. Do they violate civil rights laws? And a lot of times there isn't that level of transparency either to the consumer or to the courts or to the deployer from the developer regarding how they work. And so there just is a gap in the law that needs to be addressed through transparency measures, is what a lot of lawmakers are really focusing on. But again, a lot of this does fall out from data privacy when we're thinking about things like legal or similarly significant effects coming from profiling, right? All of that's language from data privacy laws. Things like transparency are from data privacy laws. If you look at the risk assessment requirements from, like, for example, the Colorado Privacy Act regulations and the risk assessment requirements in the Colorado AI Act, they're not that far off. So it really is just an extension of that and trying to fill some of those gaps.
And I'll say that we're going to learn more about this, I think, soon from California. There was just introduced in the California Assembly ACR 52, the Safe Driver Incentive Programs resolution. So this is the Assembly, assuming they pass it, actually calling on the California commissioner of insurance to allow these driver risk scoring automotive telematics services to be offered in California. California is one of the very few states that actually does not allow this kind of driver risk scoring at all. And they've now stepped into this question and say, well, actually, you can get better underwriting, you could incentivize good driving, you could improve road safety if you allow this kind of risk scoring. And then, of course, the bill adds, and it should follow all the California privacy laws, and and make sure to be fair. So they may well, if this process, I expect this process will go forward in California, the insurance commissioner may get into it because it's going to be, in this case, up to them to actually make the specific rules beyond what's in the in the general California privacy law. But I think so you could call this AI regulation, or you could call it insurance regulation, or you could call it road safety regulation, or you could call it privacy regulation. It doesn't really matter. I think we are now teeing up, and what I call in my little LinkedIn piece, this era of modern privacy, where consumers actually want to share their data for some purpose. They want to get value out of their data. They want a better price on their insurance. They want to know more about their banking situation. They want help planning their retirement, et cetera. So they want to share a lot of data. It is sensitive. It actually needs to be sensitive because they want to get some value, but they also want to be protected. And so I think that the questions that I hope legislatures around the country will get to is, how do you do this seriously so that people feel they can share this data, have it be put to what are sensitive and potentially harmful uses, but to make sure it's done fairly, and that you avoid the Texas situation where what you have is this kind of octopus like workflow of personal data that's going here, there, and everywhere without control or anything.
Let me put an issue on the table. At a round table we were having at one point with some of the civil rights groups, the question was, what are you trying to do with these AI laws? Because you're talking about them as a civil rights priority. I said, don't we already have these civil rights laws? Are you looking to extend them beyond the current housing and employment? I mean, because that's a bit hard. I mean, clearly there are ways where we do things that are unpleasant, but aren't they really unfair or deceptive? And if they're not, I mean, are we worrying about, are you marketing certain kinds of movies to, different audiences that might correlate with race? Is that what you're really trying to? And he said, no. He said, it is the traditional civil rights, but it's not clear that the law, when it goes to digital issues in many states, actually well protects those. Or even if it does, you don't have the transparency where you'll have companies say, well, I just used that model. I'm not on any obligation to go figure out this. And I can't even, because I don't even have the data. And so the mandate they argued for these laws was the transparency, as Tatiana mentioned, or the fact that there actually may be some legal gaps in being able to actually enforce some traditional rights. So don't we need these laws perhaps to actually protect? And I will note that a lot of the laws, although there's been some argument, these are EU acts, these are laws, at least like Virginia, some of them are broader, but like Virginia and some others, pretty much tightly tie to already protected legal, risks that are already, covered by civil rights laws. So don't we need these AI laws for that purpose? I guess that's a challenge to Danny, but welcome both of you.
So I guess I think, again, if you look at what's so interestingly, also the Texas complaint also said that Arity was liable for failing to register under the state insurance laws. So I think the answer to your question is probably in a number of these sort of high risk sectors, there probably will be some attention needed to the question of whether those particular sector-specific regulations are really doing the job. The principle is probably there. The principle that in insurance underwriting should be fair, and part of that is got some notion of privacy protection in it. California is going to have the same question. It's been kind of floating around, as I understand, before the California Insurance Commission as well. So they're going to have to look at some of the nuances here, and to your point, how do you determine whether these models, for example, are fair? That's a question that insurance regulators know how to look at. How do you determine a hiring practice is fair? Employment regulators know how to look at those questions. Whether some additional regulation is needed or not, or whether it's just a question of more, careful, forward-looking enforcement, I think that's going to vary. I'm interested in Tatiana's view about what's out there.
Yeah, I think it's an interesting question, because it sounds like almost what you're saying is like maybe it should be more of a sectoral approach rather than these laws that are focusing on multiple areas all at once. And I do find that compelling to an extent. I think the question becomes, now do we want a sectoral by sectoral approach as we originally did in privacy, where we have HIPAA regulations, and then we have GLBA, and then we have all of these different types of areas, and whether that is an effective approach. I think a lot of people say it wasn't. Other people say that it was. And it's a good question as to whether it's good to be more sectoral. I think a lot of these lawmakers are trying to handle a lot at once, and like that is inherently creating a lot of complications and questions. And then I do think there is going to have to be sectoral by sectoral. And I think, how do you figure out to deduplicate requirements, which is why I think a lot of lawmakers are trying to figure out, how do we exempt things like insurers who are already covered by insurance regulations? For example, Colorado already started this process for updating their insurance regulations to incorporate AI. So they're exempt from the AI law, but other areas that haven't started that updating process, they're within scope. But you do have to find that balance, because you don't need to have duplicative kind of coverage, but you do need to have coverage.
Danny worked on a federal bill during his days in the White House, and the question comes up from Michaela Lewandowski as to do we think a federal AI law will happen? Well, you see the comments that were poured in just this past week to the White House request. Most of the commentators were not calling for a federal AI law. If you were, we, and I think a couple of others, said, do a privacy law if you want to take the first step towards putting rules around AI, because you really can't do an AI law without actually doing things like what is personal data and what are the basic rights and so forth. And then you can get a bit further. So I don't see any serious federal engagement around an AI law. We do see some interest. Congress has started up a task force. They're taking input. We'll see whether starting over with a fresh start gets us someplace.
I'll just say quickly, I would want to make sure that I think, as you know, Jules, I'm a huge advocate of comprehensive federal commercial privacy legislation in the U.S. We need it. We should have had it a long time ago.
And that proposal under the Obama administration was preemptive of state laws. May I remind you?
Yes, it was. Though what it would have done, for example, to like an insurance regulator who wanted to look at the use of models, my guess is they certainly would have argued that, of course, they could still regulate the insurance underwriting process. And I think they would have been right. I think that would have been the right thing. And I think whether to the question, whether or not we have a federal privacy law, we have a lot of both federal and state jurisdiction to address a lot of sensitive uses of data, whether it's in employment or drug safety or transportation safety, or as we were talking about, insurance. What I'm most concerned about is to make sure that those regulators and enforcers, wherever they are, have the expertise that they need to be able to evaluate the behavior of these models according to the performance metrics that they care about. Because I think what the FDA cares about in the way that a AI-driven drug delivery device needs is very different than what an insurance commissioner might worry about in the way that a driver risk model behaves. And I'm a little so I think that, because what I think is going to happen with this AI technology and what we already see is you have companies that offer services want to figure out how to do it better or do it cheaper or do it faster or whatever it is. And so they're already before their relevant regulators. They know what those issues are. Their regulators know what those issues are in terms of the underlying regulatory goals. And I think we just have to make sure, regardless of whether we have a federal privacy law or not, we need to make sure those existing regulatory processes work well and can stay up to date with this technology, because otherwise the regulatory process will slow things down and create confusion, and consumers will be subject to all kinds of risks. So that's where I'm actually focused these days, is on making sure we have that expertise where it's needed.
In the comments, Keir Lamont of our team points out that Texas has got an opt-in there for sensitive data, whether it's for privacy or AI use. And, HIPAA, for instance, which doesn't have the word privacy in it, it's all about portability of data with the privacy protections needed to ensure that the data can move around the ecosystem to all the appropriate players. And when you have some of the state bills where people are not, oh, wait, where does data need to move around? So the driver folks are coming to this with is it a bad thing if people have incentives to drive safe because of some app that is going to, monitor that and tell them about it, or penalize them maybe even about it, the way we do with insurance and other things to penalize you for being a bad or risky driver. They're going to, come to it hopefully with a view to sort of privacy, but also a view to what should the societal default be. And we've made some decisions here around health data that the societal default should be no data, or, only if you're in a position to get consent, which is clearly appropriate for a whole bunch of places, and clearly a huge problem for things like having, diverse data sets, finding people. The Maryland law, which is, in my mind, a real strict data minimization one. I live not that far from NIH as you as well, and clinical trial recruiting and all the funding and all the clinical trials. We have a huge number of them in this area. It is a great thing, both for people who need access to that as well as research. They need to market and find people, and they're having a real, Kirk Nara just posted an interesting leading health privacy lawyer, I'll share his as well, about some of the challenges that the people whose job is to market to you to find the people who belong in a clinical trial. And a lot of these are very, niche things. You need men of a certain age, women a certain age, this sort of medical history, this and that. And clearly that's the kind of use we want, but it is not carved out because a state privacy legislator simply was reacting, to concerns about, opt-in. And, how do you argue against opt-in when you're not someone who understands the way data actually is used in a particular ecosystem?
Right.
Let's just get a comment or two from some of our other commenters, and then we'll let people go back to their workday. Bob Lawler, formerly the lead at the Internet Accountability Foundation and a longtime privacy executive, does a lot of work today with small startups, and they want to know where to start. And they say, well, there's no AI law. So she says, as Danny is suggesting, should those AI startups look at state privacy laws as a foundation for AI governance, along perhaps with the NIST RMF? Gabriela Zanfer Fortuna, our global privacy lead, does not stop repeating, GDPR is an AI regulation, regulates a lot of AI, regulates some of the AI that is also regulated by the EU AI Act. There's cases and cases and cases. So if you're in Europe, you got an AI law before the EU AI Act even is relevant to you. And I guess you probably agree that, start with the state law and start with FTC jurisprudence around fairness and deception, and consumer protection law does a lot of this. Before we even talk about privacy law, consumer protection law, which is sort of where the FTC has built its privacy law. It doesn't have a lot of privacy statutes. It's built its privacy jurisdiction around consumer protection law. So we're forgetting also about the AGs and their current pretty strong, almost every state has a deception. So put privacy aside for a second. Can consumer protection law solve all this, frankly?
Can it? Sure. But should it? I think a lot of people would ask the question, does that provide enough clarity to businesses if you're kind of doing a case-by-case basis and figuring out what governance looks like in that mechanism instead of upfront requirements or upfront guardrails on what you should be doing, right? So you can look at things like the FTC Rite Aid case and see exactly how the FTC, at least in the former administration, was looking at AI governance just through that one case. But Rite Aid might be like, well, we didn't know this before, and now we have to delete our model because we didn't know that we were supposed to have all these governance measures. So it is a little bit of a trade-off, but I do think there certainly is a way to be able to address these governance questions through consumer protection. I think there is just a question of vagueness and what clear guidelines might look like.
I'll close with a prediction. When we started out many years ago, we did a lot of best practices because we didn't have as much legislative structure, and companies wanted something to point to because they were having to make hard decisions, not about, is this actually going to be illegal, but is this going to be wrong or controversial or disruptive or a consumer's not going to like it? And I think if we have a bit of we still have a lot of legislation to deal with, but if we don't rush forward with some of the other AI or other practices, we've got another opportunity to fill those in. And this is an area where trade groups and industry and groups like us need to do better, because people actually want a point of reference, a norm, and then they can debate whether they feel comfortable going further. But otherwise, it's a rush to the bottom or a lack of clarity. I think people, when they see a clear playing field, most reasonable companies like to follow what they're told is the reasonable, good practice. And it's not perfect. It's not as good as perhaps a law, but it plays an important role in soft law. So I think you're going to see a re-interest in that. We did a best practices with the leading companies that do AI in employment, because they understood there were sensitivities about how to use AI in hiring. Every resume you send in today, if anyone has sent in a resume, right, it gets sucked into some AI tool that then ranks it and lists it and, just helps people manage it. There's a lot of AI already happening in the employment and recruiting space. And the companies wanted to talk to us, talk to each other, talk to experts, talk to civil society, talk to the EEOC and regulators, and put words on paper that they could all collectively agree to. So I think we're going to see a resurgence of model practices, standards, best practices. And maybe it's not terrible if law takes note of those things before it enshrines some of these things into law. All right, final answer to Cynthia Gayton. If you're a web-based company, wouldn't you have to comply with all the state laws in which you enter into contracts with consumers? It's not even contracts. You market to, you have significant contacts in a state. They're going to tax you, and they're going to make sure you don't steal or rob or do deceptive things to their consumers. So yes, the benefit of the web is, yay, you're in business with everybody in the world. The downside is, if you are actually intentionally in business in all sorts of jurisdictions, you gotta follow their rules. I was a New York consumer affairs regulator. If somebody was doing bad stuff to New York consumers, I might not make a top priority chasing someone in Russia who I actually had no way to do something about. I might refer that to the FBI. But if they were in the US and I was going to be able to serve them and sue them, I wasn't going to say, I can't help you, senior citizen who lost your life savings because the company is in California, or whatever it was. So, Danny, great to see you. See you around town for sure. Hey, folks, our big annual event, Tatiana is going to be there. Danny's going to be there, where we will be debating many of these issues with some of the leaders in the world, and it's certainly in the US. In June, we'll post a link to it. please do join us at the second annual DC Privacy Forum. Have a great weekend. Thanks, Tatiana. Thanks, Danny, for joining me. Thanks to all of you chimed in and those who commented.
Thanks all.